Actually, I am not prepared for this meeting. Okay, my brother is admitted ICU, so but I wanted to come here. Okay, see, one question I in my personal situation. My personal situation. My daughter is an American citizen. My spouse is a schizophrenia patient. EMI. Okay, now in this trust, and now my daughter is major. Okay, she is doing graduation. So how do I build this trust? Because she is an American citizen. Are there any clauses involved here?
Private Family Trust, that is Indian Trust Act 1882, covers NRIs as well. Yeah. With special clauses and with a clarity. So you are not restricted, to be honest, that okay, if she is an American citizen or an NRI, that is it valid or legal to make her a part of this family trust? Yes, legally she can become a part of this trust. Just make her trustee, okay? Settler will be you, and beneficiary will be her as well, along with your wife. Yeah, fine, no problem at all. Yeah. Yeah, because we have got Indian government has collaborated with many, moreover I speak about US only, had collaborated, they should not leave their rights in Indian, like many people they have property issues and all those. If she is having OCI, the great point actually, but yeah, so she is, I'm very much sure and 100% sure that she can become a part of a private trust, and she can become a trustee. She can become a beneficiary along with your wife. Yes. But truly in your personal case, yeah, I'm 100% sure that your daughter can become a trustee and beneficiary along with your, and the clauses, it's all, again I'm saying, it's your complete freedom. That particular piece of paper, you can have your complete authority and freedom, what you want to control, to whom you want to control, to whom you want to give authority, where you want to get okay, done, khatam, ho gaya. You have that much authority, being a settler.
Can I date for this trust deed? I meant to say in future, because now I am alive, I will manage things. I am alive, I will manage things as a caregiver for the PMI. Okay, so can I prepare a trust deed with a future date? I will say, saying that with the event link. Yeah. Okay, and the other question I have is, can I have multiple trustees?
Multiple trustees will, in special, in very special condition, you can have, but that will be risky.
No, the reason I will link them to the events again. Say, for example, trustee 1, trustee 2, trustee 3. Okay. Correct.
Yes. Apart from your daughter, you can do it.
What is the cap? What is the cap? Okay, fine. I think I am missing trustees and also you said some other words, but not beneficiary, protectors or some. Who is a protector? Hmm. See, if I want to see, let me take my case again. I want to put my friend and my sister as trustees. Can I do that along with my daughter? Yeah. If I'm trusting them, yeah, I'll put that. Uh, uh-huh. So,
into very deep. Okay? Again, who is the friend, whether his property is self-acquired or ancestral. Again, that come clauses just like ma'am in ma'am's case we saw. So it's completely depend upon case to case. If it is self-acquired, if he acquired self, then it's okay, he can make it, no problem at all. But if it is ancestral property, again, then no objection certificates and settlement deeds. There are n number of documents you needed for making trust. And if you will add in ancestral property, if you will add that person, your friend, that will become a public. And ultimately government will take over that. I don't want pleasure of giving anything to government. Right?
yeah. See, in my case again, I have a ancestral property, and there is a will for that without being registered. It can be challenged. Okay, fine. And I have self-acquired property as well, two of them. And on the will, one of the sibling is a witness. It's not registered. Uh-huh. If I can get NOC from my siblings. Mhm. Sure. Okay. Fine. Thanks. My questions. So now, you said succession certificate should be there. Hmm. But I have a family certificate, not a legal. Okay. So, okay, then. Nominee may get the money, but again, all the legal heirs are eligible to get that money, right?
Property, if you are going like to challenge, if you think like no one can challenge that thing, go to court and apply for legal hardship certificate and succession certificate. Both will protect you for everything. Attach the will. Will is the most important. See, here will is important in ma'am's case, actually. Along with will, she can go with a private family trust. She can build that. Only in someone's matter who is only like, okay, fine, I don't have a, okay, he can do it like, he can go with the option of private trust, he can go with. In your thing, it is the ancestral property. So it's a long kind of a process that you need to follow. So again, most important document in your case is, sir, succession certificate, legal hardship certificate, and moreover, will. And come after like collecting all these three documents, then go with a private family trust. That will be completely 100% secure. Well, that again depends upon the trustee you are putting.
It is very clear now that will can be challenged, but private trust deed cannot be challenged. Okay. So trust deed is far superior than the will. Okay. But if a part of the assets you want to give it in will, you can give it, and the other part, how much of assets you want to give it to the trust, you only the decider as far as this is concerned. So always the trust deed is far better than the will, okay, which can be challenged, especially an ancestral properties and other things are included. Then as far as nominee bank is concerned, nominee is not a title holder, he will not get rights to use anything, he is only an intermediary. So again, a nominee also is guided by the trust deed, where you write a particular FD, interest on FD has to go to the beneficiary, nominee has to follow that. As simple as that. Now, Ritu Ahuja is here and he wants more clarification. Ritu. Huh? Huh? You are Ritu. You got you gone. Okay. Now Ahmad, please come. Ayuddin Ahmad. Others also, please think of your questions and be ready. This is a very great opportunity you are getting.
Madam, now trust deed and it is there, suppose. Again, registration of society is required for that. Both are required. How?
Registration is most important and mandatory process of the trust. Yeah, it should get registered with under Trust Act, Indian Trust Act. That is mandatory. Without, registration, it's nothing. That is only a piece of paper.
Suppose the ancestral property 40 years back, forefathers has given to their children. Now, for example, for me. Now, that mutation has not done. What to do now?
Coming back to the ancestral property, I would like to ask you, like, have you received partition deed? Again, that is registered or unregistered. Yeah, so anyone can challenge, and that is a mess actually in your case, sir. Because unless and until how many siblings you have, how many brother and sisters you... you're in physical possession, you're saying, right? It's completely good. So your case is better than others' case now. Okay. So now it's a high time for you to go with legal kind of a work. Get the mutation done, sir. And get the no objections from every of your siblings. Like, because anyone, as I have already shared, like until 5 generations, people can come and challenge. Right now, if you are in physical possession and you're controlling everything by your own, you're saying that, sir. But if someone XYZ will come again and he will say, no, I'm paying tax. This is my slip. So again, what court will do? Okay, fine. Sir, now it is contested. Yeah, then mutation is not there. No? See, yeah, in... moreover, it's paternal or maternal from your mother's side or your father's side. Father's side. So 5 generation can challenge, sir. And from mother's side, if it is maternal property, ancestral property, then definitely up to 3 generations. 3 maximum you can stretch. I mean, many people, they don't have a idea about like, okay, we can go, and some like they can like challenge until 4 generation. It is called decree. First, second, third kind of. And we are in Telangana. So nowadays, like Telangana people. Oh, which document, sir? Here I would like to share one more important thing, that I know, like, I mean, being an advocate, I will say that anyone is coming and any one of you is going for making any kind of a legal document, where you need to, like, keep in mind more important points. First of all, that should be, if it is immovable property, that should be like, like 100 rupees stamp paper, and that should be attested and notary should be done. Randomly, what advocates usually they do, that they'll purchase like 100 rupees of bond paper and they will just draft. And drafting is more and more important here again, that what he is doing, what he is putting, because many of the advocates, they leave the main clauses actually. आपके इसमें, आपके कंडीशन में सर, वो डॉक्यूमेंट देख के ही पता चल सकता है कि उन्होंने क्या डाला है, और वो अगर अटेस्टेशन और नोटराइज हुई है, देन डॉक्यूमेंट हैव अ लिटिल वर्थ टू टेक और इन फेवर और अगेंस्ट ऑफ यू इन द ऑनरेबल कोर्ट. तो यहाँ पे जब भी आप कोई भी बॉन्ड पेपर यूज कर रहे हैं, दैट शुड बी नोटराइज एंड दैट शुड बी अटेस्टेड बाय अ पर्सन, लीगल पर्सन. सो इट्स कम्प्लीटली सर, इन योर केस, आपके इसमें डिपेंड करता है अभी. और मेरा एडवाइस यही रहेगा कि गो फॉर अ म्यूटेशन एज सुन एज पॉसिबल, that someone should not come and challenge your thing. Sure.
Now I request Anuradha to come over to the dais and put a question, because it is to the benefit of all the people. So they would like to.
If you could have included a child with the PMI, who is a dependent child of PMI, and various clauses, and what Rajesh would have written in his custody, the number of different scenarios, it would have been more. It would have been more helpful to us. So here he has got 2 normal children. Rajesh has got 2 normal children. Whereas if you would have given us an example that one person is an BMI, and more relevant. Next is mostly most of the dependent children, they are here at least. Mental illness. So in the mental illness, mainly it is of 2 types. Like, one is bipolar and the other is schizophrenia. So here he has got 2 normal children. Rajesh has got 2 normal children. Whereas if you would have given us an example that one person is an BMI, and
Uh,
In bipolar, such types of PMIs, patients with persons with mental illness, have two scenarios. One is they have depression or they have mania. Mania, I think you understand mania. We have, everything is like opposite to depression. Then schizophrenia, most of the patients here is they don't have any insight. That means they are not in contact with reality. So definitely, but when they are stable, they are partial insight. But when they are not stable, they are not in a position to make a proper decision. It's relevant to themselves also. They can't take a proper decision for their welfare also. In that case, so most of us here will have no other option but to form a trust. Okay. My question is that in the Mental Illness Act, huge powers have been given to a PM. Now, if we, you have to give us guidance. What you are asking us are references. We should tell you what are requirements. Here we are at a loss. So most of the people here, we would like to have a draft clause, and then from there maybe we can pick up what all in future we will be needing. So, and everybody, 50% I think have a common requirement. The other 50 would be personal. It will differ. 50% will be like we have an X amount which we will be putting in a trust. We will be describing the trustees also. That part is common for 50% is common. But the next would be like their source of income, like you said, some may have movable, some may have immovable, some may have fixed deposit or mutual funds or whatever. Secondly, we must keep in mind that there will be two assignments given to the trust. One would be the financial, which may be taken care of the chartered accountant. The other would be the day-to-day management of a PMI's life. How do we address that? Who's going to take care of that? Out of the trustees, one will be given the power or one will be given the duty to run the, and again, with the PMI, there will be again two scenarios. A person may be independent in looking after himself, like, the day-to-day regarding his upkeep or his requirement of food or his pocket money, whatever. But he will need an assistant. That will be one scenario. The other would be like he'll be put in a rehab. And there, not much, you just pay the amount, but then again, whether that person, the PMI who is in the rehab, you need to monitor, someone has to monitor whether he is being taken care properly in the rehab. So these are so many questions which we have. How do we incorporate this in we will not there. Or maybe 10 years down the line when the parent is around 70 or 80 and he is not be in his lifetime only, like we have to hand over everything to the trust only. So these are so many questions which we have.
Thank you. One, yeah, one. Okay, good. So, one thing, member, before, be- okay. Okay, thank you. We understood the concerns of Honorable and all other caregivers. Before she answers the legal aspects of it, the management aspects of the trust is what she attached to one thing. Secondly, as a settler, you must have a very clear mind, because advocate will not have what he has to do with you. And there is a diversification of assets. Each caregiver is not same. His immovable assets, his ancestral property, his own earned money is different, and his movable and immovable assets are different. So it is not common. So each trustee is unique, which you have to discuss clearly what is in your mind. You must be very clear about it. There is no doubt about it. It's not common to all caregivers. The difference is that. And one more thing is, as far as management of the trust is concerned, it depends upon the trustee you choose. If you are trusting that he will handle it as per the need, and if a person is in rehabilitation, and the trustee has to only transfer the rehabilitation fees monthly, whatever you write there. He has earlier the work is being done by you as a caregiver. Now you are handing over your work. That means he will execute the deed, stepping into your shoes, and you have to choose the trustee, such a trustee that you have to apprise him well in hand how you are giving care, and same care has to be, you have to train. If the trustee is not trained in caregiving, you have to train him how you are handling, and then hand over the management of the trustee to him, so that whatever doubts you have in your mind will be taken care of by the trustee. That is one thing which before I giving you. Because an advocate can only give replies legally and legal aspects of it, and the management of an aspect is between the trustee and the settler. Trustee and settler. Advocate will not. And the final decision of the trustee is final. Then advocate also cannot interfere. He writes on a deed and leaves it to the trustee. That is one thing. The other thing is Ramakrishna Garu has multiple trustees. That also I will put it. Too many cooks spoil the broth. Too many cooks. And one more thing is, let me clarify that if there are so many trustees, there is only one trustee who is the executor. They cannot be all the three executors. If all the three are executors, they will fight among themselves and they don't want. And normally when there are multiple trustees, they will elect and give authorization to a managing trustee to operate the trustee. There can be only one cook who can cook properly. If one put salt, another put your chili powder, then you are bad taste. So, in that case, in the trust deed itself, you have to say that if that also as a condition, that trustee 1, trustee 2, trustee 3, like after his operation is over, the trustee 2 will take care of something happens to the trustee, so that the continuity of the trust can go on. Yeah, backup can